What is Ultra Vires? Ultra Vires is the modern technical designation in the law of corporations of acts beyond the scope of their powers, as defined by their charters or acts of incorporation. A term used to express the action of a corporation which is beyond the powers conferred upon it by its charter or the statutes under which it is instituted. The doctrine is of modern growth. Its appearance dates from the year 1845, being the first prominent mention. There are three classes of cases in England in which the question of ultra vires arises. First, cases in which one or more of the shareholders seeks to restrain the officers of the corporation from engaging in transactions unauthorized by the charter. Second, actions brought by third persons against corporations to enforce their contracts, in which the defense relied upon is that in making the contract, the corporation exceeded its corporate powers. And third, similar actions in which the defense is that the directors had exceeded not the powers conferred upon the entire corporation by law, but those conferred by the shareholders upon the directors by deed. It is said that the true and primary meaning of the doctrine is that a corporation has certain powers only, and that it can be bound only when acting within the limits of these powers. When the acts of corporations are spoken of as ultra vires, it is not intended that they are unlawful, or even such as a corporation cannot perform, but merely those which are not within the powers conferred upon the corporation by the act of its creation. A corporate act is said to be ultra vires when it is not within the scope of the powers of the corporation to perform it under any circumstances, or for any purpose, or with reference to the rights of certain parties, when the corporation is not authorized to perform it without their consent, or with reference to some specific purpose, when it is not authorized to perform it for that purpose, though fully within the scope of the general powers of the corporation, with the consent of the parties interested, or for some other purposes. As a general rule, such acts are void and impose no obligation on the corporation, although they assume the form of contracts, inasmuch as all persons dealing with a corporation, especially in the state or country in which and under whose laws it was created, are chargeable with notice of the extent of its chartered powers. It is otherwise as to laws imposing restraints upon it, not contained in its charter, where the contract is made or the transaction takes place without the limits of the state or country under whose laws the corporation exists. If, however, the corporation receives any money or other valuable consideration under such a transaction or contract, it is not doubted that upon rescinding or repudiating the act or contract under which it was paid or delivered, it could be recovered back in an appropriate action. So too the artificial body, the corporation, is liable to be proceeded against by quo warranto for the usurpation of powers in its name by its officers and agents, and its charter may be taken away as a penalty for permitting such acts. The defense of a want of power to bind the corporation not being available in such cases, since it would lead to entire corporate irresponsibility. Among the rules laid down by a recent writer as the leading principles of this doctrine are these. A corporation has all the capacities for engaging in transactions and management which are given it expressly by its charter, or impliedly given by its reasonable implications from the language thereof. Capacities or powers for management may be given by wide general language. Beyond these powers, they have no capacity or powers, and cannot legally or validly engage in other transactions. Corporations cannot be rendered directly liable upon ultra vires transactions, but must account for benefits received therefrom. As long as the transactions remain executory, it is established that it cannot be enforced. But if it is executed, though in England it cannot be enforced or sued on, yet in the United States there seems some doubt whether the corporation will be allowed to set up the defense of ultra vires. In both countries, however, unquestionably the corporation must account for benefits derived. Special proceedings in themselves, ultra vires, will sometimes be upheld as having been rendered necessary by unexpected circumstances. Any party to an ultra vires transaction may set up the defense thereof, and any corporator may call upon the courts to restrain the corporation from engaging therein.